Hello, in this session I am going to discuss administrative law, scope and nature. The objectives of this session are to understand need and importance of administrative law, define what administrative law is, explain the scope and nature of administrative law, discuss the sources of administrative law and discuss the justification and need for administrative law. Administrative law came to be recognized as a separate branch of legal discipline only in the middle of 20th century. Today, it has become major area of study separate from constitutional law as administration is ubiquitous and impinges freely and deeply on every aspect of individual's life. The administrative process has increased so tremendously that today we are living not in its shade but shadow. If we look at the need for administrative law, it basically arose because of the change in the scope and character of government from negative to positive, from the laissez-faire to the public service state has resulted in the concentration of considerable powers in the hand of executive branch of the government. Today's state is protector, provider, entrepreneur, regulator and arbiter of disputes as well. The phenomenal growth of administrative power, though necessary for the development and growth, at times spell negation of people's rights and values. Administrative law thus becomes dharma, which conduces to the stability and growth of the society and the maintenance of a just social order and welfare of mankind by reconciling power with liberty. Now, let us see what is administrative law is all about. It is a branch of public law. It mainly concerns with organization, power and functions of executive authorities, how administrative authority get public power, procedural rules for the use of this public power, substantive requirement administrative authority have to take into account when using their powers, and finally the objection, procedures and judicial protection against the use of administrative powers. Thus, administrative law attempts to regulate administrative space, domestic as well as global, in order to infuse fairness and accountability in the administrative process necessary for securing equity and inclusiveness in the domestic as well as world order. Broadly, there are four bricks of administrative law. Firstly, prevent abuse of power. Second, encourage citizen to get impartial determination of disputes. Thirdly, eliminate encroachment of rights of individual, and finally to bring accountability in the functioning of government. If we look at the nature of administrative law, it is a law but not a law in the lawyer's sense. It is not a codified law like property law or IPC or contract law. It is a law in the realist sense of the term, which includes statute law, administrative rule making, precedents, custom, administrative discretion and many more things. It also includes the study of something which may not be termed as law in the true sense of the term, such as administrative circulars, policy statements, memorandum and resolution, etc. Besides this, it includes within its study higher law as well, like the principles of natural justice. In India, administrative law basically and wholly remains a judge-made law. It includes the study of existing principles and also the development of certain new principles which administration and a quasi-administrative agency must follow while exercising their power in relation to the individual, that is the principles of natural justice, reasonableness and fairness. Administrative law primarily concerns itself with the official action which may be rule making or quasi legislative action or rule decision or quasi judicial decision, rule application or administrative action, or ministerial action or pure administrative action where no discretion is involved. Besides these main actions, the actions which are incidental to the main action are also covered within its study. Such incidental action may be investigatory, supervisory, advisory, declaratory or prosecutory. One of the main thrusts of the study of administrative law is on procedure by which the official action is reached, because if means by which actions are reached are not trustworthy, the end cannot be just. There is a bewildering variety of the procedure which the administrative agency follow in reaching an action. Such procedure may be laid down in the statute or may be left for the administration to devise. This branch of law also includes study of the control mechanism by which administrative agencies are kept within bounds and made effective in their service. to the individual. This control mechanism is technically called the review process. Administrative action may be controlled by court exercising writ jurisdiction, court exercising ordinary judicial powers through suits, injunction, declaratory actions, statutory authorities like Ombudsman, Human Rights Commission and other investigative agencies, higher administrative authorities exercising control. Public opinion and mass media are also important control on the administration. Civil society and interest representation also play an important role in controlling the arbitrary exercise of public power. Now, if we look at the sources of administrative law, we will find that it is ever growing sphere with no fixed terrain. It is found all across the board and still to be found, invented, discovered and traced. It is an integral part of the constitution. It not only reflects but also shapes the constitution. Most part of it is uncodified and judge made. It is basically based on maxim ubi jus ibi remedium. That means where there is a right, there is a remedy. When you study administrative law, you will find that it primarily unfolds via judicial decisions. Justices and courts arrive at the sense of the limits of the executive and administrative decision making powers and of their own judicial review powers. It signifies a one step forward, two step backward adjudicatory movement. It is basically a result of judicial seesaw. Now, let us see the relationship between constitutional and administrative law. There was a time when the books of constitutional law had a chapter on administrative law. That was the beginning of administrative law. Today, administrative law is recognized as a separate, independent branch of the legal discipline. Though at times the disciplines of constitutional and administrative law may overlap. If one draws two circles of administrative law and constitutional law, at a certain place they may overlap, and this area may be termed as the watershed in administrative law. In India, in the watershed, we can include the whole control mechanism provided in the constitution for the control of administrative authority, which includes article 32, 136, 226, 227. It may also include the study of those administrative agencies which are provided for by the constitution. Further, it includes study of constitutional limitation on delegation of power to the administrative authority and also those provisions of the constitution which play fetters on the administrative actions like fundamental rights. One of the emerging areas of the field is global administrative law. Tremendous increase in the reach and form of transgovernmental regulations. Therefore, the need to develop a strong body of global administrative law to regulate the forces of globalization. Global administrative law must address problems of global lawmaking, global administration, global adjudication and global accountability. The purpose of global administrative law may be to develop principles and norms necessary for reconciling claims of globalization with the claims of human development. With this, I come to the end of this session on administrative law, scope and nature, and leave you with a brief quiz which you will find easy, and thank you for watching the video.